Workers' compensation claims, injuries that occur on the job. Well, when someone suffers injury and yet somebody else is at fault and they collect from that person, do they have to pay back the workers' compensation insurer for the amount they covered from the other person who was at fault? Well, the answer is generally yes, but what about U.S. Postal Service workers who are working for a quasi-public company? How about them? Do they have to pay back because they get their reimbursement from workers' compensation through the United States government? Well, that question takes us to this week's case, and it's an interesting case for a variety of reasons. In this particular instance, we had someone who was a postal worker, was out there delivering the mail, and unfortunately there was a defective manhole cover, and that caused the postal worker to fall, actually fell through and into the area of the street below, suffered some bad injuries, brought claim as a workers' compensation claim because it happened and it was a case that arose out of the course and scope of employment. They received reimbursement for that, $88,000, and then sued the city. The city wound up settling the case for $240,000. Well, the United States government jumped up and said, we want to be reimbursed for the money you got from the city that was at fault. The postal worker said, well, I understand I generally have to reimburse if a person was at fault, but this was a city, this wasn't a person. And I look at the statute, and the statute says that I should reimburse you, the United States government, if another person was at fault. And the word is person, P-E-R-S-O-N. It doesn't say city, state, or any political subdivision. It says person. A city isn't a person, and therefore I don't owe you guys, was the argument that was made by the plaintiff. Okay, the case went forward, went up on appeal. And on appeal, the court looked at it, and it looked at the specific statute that dealt with reimbursement that the United States government could have for U.S. employee injuries. And it said, you know, look at this. And the statute specifically says if some person other than the United States were at fault, there would be reimbursement. Well, obviously, because of the way it was written, saying some person other than the United States, the statute, Congress, when it wrote the statute, considered the United States, for the purpose of the statute, to be a person. Therefore, if the United States is considered a person under the statute, any political subdivision, whether it's a state, a county, a city, is considered a person under this statute. And therefore, we find that you do in fact owe the United States government reimbursement for all monies it paid under the workers' compensation claim you possessed. Okay, so what do we learn about this? Well, what we learn from this case is statute interpretation is something that needs to be done very carefully. And sometimes words taken in isolation, such as person, really aren't what they appear to be, because you have to look at the overall context in which the word is used. And in this instance, the word was used in such a way that it was clear that Congress referred to the United States as a person, and therefore, by implication, all other political subdivisions as a person. Now, as an aside, ever since 1912, the law has, in the United States, generally considered all corporations and companies to be persons. And the reason for that is that a lot of statute is written in that language, and it says people, persons, etc. And when you have non-natural persons who are involved in activities, as we certainly do today, whether it's a city, whether it's a corporation, whether it's a partnership or some other business entity, well, that entity needs to be dealt with under the law the same as a natural person. Okay, something we learned here today. Something we learned as we learn every week here on the video blog as we look at real cases involving real people so you understand how the law works. I'm David Allen.